So Munna Bhai MBBS, you remember the movie, right? We created a ad film in Flipkart again. So all these, child artists, do this campaign on Big Billion Days.
Then using AI platforms to repurpose content and build something fast, specifically the startup environment.
Accenture, brand Accenture only. So they created one company and they have created a logo and they said that we are Accenture, nobody can stop us, and we are the owner of the mark. And this matter went to Delhi High Court. In Delhi High Court, they realized that their marketing team, one of the guys, just got it from the internet, this particular logo, and just changed the configuration of the logo. Because if you see it from a different angle, you can easily make out that it's same logo which has been created. So they've been gone.
Hello, everyone. Welcome to another episode of Wisdom Over Hustle. I'm your host, Rohan, and also the co founder of Zavops. So, today we are taking an interesting turn in terms of our panelists. Since we've been talking a lot about MarTech and AI side of things, it was a valid question that was being asked on in terms of the copyright, because there's been a lot of discussions around copyright infringement and laws around it. So today we have a very interesting panelist on our show. I have Rahul Jain, who's the partner at Hammurami Solomon. It's a firm, and his area of specialization happens to be in the areas of copyright infringement, intellectual property, and he has been working with marketers, so he has a very interesting point of view and take on marketing, specifically IPR and trademarks related to marketing. Also from a startup point of view. And so, welcome Rahul. Welcome to the show today. Finally, we made it after a lot of deliberations and talks. So, before we go ahead, could you just give us a brief background about yourself, how you got into IP laws from a law point of view? Because I don't know, I'm not sure whether it's as lucrative as doing criminal law or any other line of work.
Yeah, thanks, Rohan. Thanks for having me. So Rohan, I am a lawyer with around 2 decades of experience. I've done my law in 2005, way back in 2005, and then also I've done my master's in intellectual property. So it's a very interesting story. I am from a family legal background. My mother, father, wife, all are lawyers, and so it happens to be like we do all coffee table discussions on constitutions, contract, whatever it may come in terms of legality. So I was happened to say practice in court. So my father is we are from Rajasthan. My father used to practice at Jaipur High Court and Alwar. So I was seeing that it's a very orthodox way of practicing, just civil, criminal, or intellectual, or other kind of stuff, which are very mundane to me. I've seen that as like in and out, check bounce matters, or all those regular stuff. But then I realized, and in my college days at law school, Jaipur, my mentor guided me that what would you like to do in terms of understanding the legal landscape. So I told them that I want to go internationally and want to practice in different jurisdiction countries as well. So I've been told that there is two streams which you can take in terms of international law or intellectual property. Then I realized that intellectual property is very very technical niche area. When you talk about R&D centers, marketing teams, you talk about creativity, you talk about innovation. And from that point I realized that was like way back in 2004, and then I have been mentored by my ex professors. They told me that it will be a good way to do your masters, and then I did my masters from NLU Jodhpur. So that is the starting point of intellectual property, and there are various streams, but this niche area of marketing. So I have been worked as a corporate lawyer for big MNCs. say Samsung, they have a chain unit which does marketing for them. It's a separate entity. Havels, Reliance Retail, Flipkart, Walmart. So these are the big entities which have a specific marketing teams. And we realized that when anything or any kind of troubleshooting required, then only they bring legal into it. So we realized that the sort of training is required for these marketing professionals, because see, sometimes you crowdsource it from open internet, something you have been told by your supervisor to create something, and they crowdsource. So what has to be taken from open domain, or it has to be a licensed images or content, so that whatever you create should be there in the periphery of non-infringing work, and you should not be having issues thereafter. So we realize that marketing teams have to be properly trained, and now in the age of AI, there is no doubt about
All right, cool. Thank you. Thank you for that background. Uh, I Before we go ahead, I mean, I've always asked you, and I always ask people, are there any wild stories that you have on IP? Because I know when I came across one of these panel discussions, and somebody told, and I think so. I mentioned this earlier when we had a discussion about the crazy story of, like, I found it really amazing, the Indigo airlines and the Tata Indigo fiasco. Like, there's a, I mean, I later on researched for that. There's an ongoing case for that. So, any crazy stories that you might have encountered, or in IP?
it. I have lot of them. Like I have myself faced. So in one of the expeditions, me and my wife went to Andamans, and we were like roaming here and there, and we bought
Okay.
Maza. So it's a proper bottle of Maza, and proper trade dress. So in trademark sense, the entire packaging we also termed it as a trade dress. This is being created by the marketing teams. Entire logo, color combinations, those barcoding, everything is being created by a marketing team. So we got Maza, and then I tasted, and then I realized it had a different taste. Then I saw it is written there as Ma. Then I realized how I can take Maza and Ma, both are very different. Then I seen on the shelf the way it has been put across. All the Ma's have been put across, so I just saw it as Ma. So in a trademark sense, in a brand sense, we say it as a average collection of the average consumer of imperfect recollection. That's a principle which we put in the normal layman's sense, and we try to so I've been duped. I was like, I as a trademark lawyer can dupe because of this small thing, because you just went to the shelf and you just got that masa, and it's just mine. It has been put it across in the shelf in the manner. Me and my wife both practice trademark law, and we were like, if we as a trademark lawyers can be duped, then anybody can have this, right? So that is one, and that very interesting story is there with respect to Virat Kohli. So we're doing one ad campaign for Flipkart, and we have been told that there is another very important law, metrology regulation. So whenever you create a ad, a campaign, and you write that this product is for 5 rupees, so you need to write it is inclusive of MRP. So this is the metrology regulations. You need to put across every advertisement. That's a mandate. Otherwise, you will get a notice from the metrology department. So there is a standard unit which has to be put in all the advertisement, in terms of money, in terms of MRP, in terms of weight, whatever it may be. So televisions has to be put across as a inches in terms of their screen size. But under law, it is said, sorry, under law it is inches, but as the custom, it is being depicted in centimeters. So we have been told that we need to do both. So how to do that? Because as a custom, everybody is talk about inches, as a custom, everybody is talking about centimeters. So what we did, we asked Virat Kohli to say it in a regular customary sense, but we put a one liner which is going on the video, and there is a in ASCII guidelines there is a time. So if it's a 15 seconds ad, or if it's a 2 minutes ad, or it is more than 2 minutes ad, how that particular line should go so that you can be compliant. So we have this very big law firm. They were not able to give us the answers, and then we, because when this kind of big celebrity is being involved in the ad campaign, lot of effort, lot of money is being involved, and the marketing team never budged. We want Virat Kohli because it's not about the money; it's about that the sentiment of say big billion days are going on, and IPL is also nearby. So they have to cash upon that personality and that event and that marketing stunt which they are doing in their particular company. So we actually got that particular advertisement campaign in compliance with law. So like a lot of stories are there. There's no end to it.
Okay. All right. Cool. Interesting. Uh, Now let's come to the real part of this conversation. Now I'll tell you something interesting that has happened with me of recently that I've noticed when using Gen AI platforms. Right. Earlier, books that I have read, uh, you know, and when I used to extract information out of these Gen AI platforms, right, that in what I've noticed is that the earlier this information they used to, give me a summary or some information that was there in these books out of it. But of recently, I've noticed because of probably some hue and cry about property infringement and that authors who write that, right, uh, they are being devoid of the royalties because of Gen AI being able to pull out this information and research. Because now I've noticed that if I ask questions, they ask me specific questions around the context of the book. Like if I've read the book specifically, I ask, okay, I need information about this. I've noticed even people been using this information to create content. They would not have that authentic information from reading the book. Now, with these implications, what do you see the impact on marketing for this? Like for the Gen AI generated content, where it would be at times sourced from different platforms. What do you see the implications of it, and how do you safeguard? How do marketing teams safeguard themselves from this?
Yeah. So, Rohan, very categorically, and I am probably, sort of influencer in this podcast. So I should say that, quote unquote, the information being shared in this particular podcast is only for the educational purpose, and they should not constitute any legal advice. So, see, so what you are saying is that the impact of artificial intelligence is there in the marketing domain, right? It is happening in the legal sector as well. Digital transformation of legal sector already happened just before COVID, and in COVID it has fast tracked. Now artificial intelligence transformation is happening, right? So what I believe, and considering this case law is also going on in court, I don't want to opine that whether it will go in positive or negative, but OpenAI Chat GPT is having a case with ANI Media House, wherein a music industry has also put himself in the case. So how the construct of artificial intelligence work? It's a Gen AI model which use two kind of data, right? It trains the data, or it get a user input, right? And then it creates something. So I say, if somebody uses the data, it incorporate, upload the data and say that I want something in this format, and you create the similar checklist in a different domain. So that's how we generally use artificial intelligence, Chat GPT. The question here is that what is the threshold? So artificial intelligence is not having a human existence, and it's a chatbot. Under Copyright Act, if you see, the ownership has been delved down to authors. Authors are persons, these are natural persons, right? So as such, artificial intelligence created work will not get any kind of copyright, because these are not individual owners, these are not natural persons. Now the question comes that it is being created, prompt has been given by the natural person like us. What is the threshold of prompting? What is that creativity threshold of prompting which allows that generative AI work will be given a copyright protection? So that has to be, still has to be decided, because probably that question is ongoing in various courts across US, Europe and India. So we need to decide that threshold limit, because say you have incorporated something and the human intervention is more than 70-75% to create that data. So like you're talking about an image. Sometimes you take image and then you put it in a different colorful form, and then you created a your brochure or marketing content. So how much has been taken and how much has been created, that's have to be identified. And when you are taking something now, that something has to be licensed, permitted. And there are many galleries wherein you can get a licensed content which you can upload in your robots to train them and then to create that work. Sometimes you also ask the external agencies to do it for you. So then in that scenario, there's no problem, because just put everything in your contracts that they have taken a licensed content, they are creating things in a genuine effort with all permitted usages. Then you won't be having any kind of issues. So we need to identify how this generative AI is helping to create the marketing content, and uh, if it is being used and devoted more than 70-75% by the human intervention, then I should always say that you should also get it registered. So copyright is basically, if you talk about, as soon as pen leaves paper, copyrights exist. As soon as I have drawn something on the paper, copyright subsists, exists. But if we get a registration, then we would be able to get our remedies in a proper form. Like you want to put somebody in jail, if you have a registration of copyright, then it will be easier for you to do it. Otherwise, other than that, statutory remedies allow you to do that. Otherwise, you cannot put anybody to jail. So you need to be like serious enough to create it in a genuine form and then get it registered, so that it will be easier for you to. Because see, when you create something and you don't want that others should copy it, you also want that if others should copy it, I should be able to enforce my right and stop it. Right? Otherwise, there's no usage of creating so much of good work. Right? So I remember one of the stories wherein so Munna Bhai MBBS, you remember the movie, right? We created a ad film in Flipkart again. So all these, child artists, they do this campaign on Big Billion Days. So we created that particular ad campaign through these directors and producer. Actual, I don't remember the name. I was just forgetting. The actual director of the movie created this thing. So, but what happened? So you remember this tune comes. So this tune was given copyrighted to Sony Pictures. So when we are creating the movie, this particular ad campaign, my this producer director told us that we don't have this movie, songs, right? I thought, boss, but you're the owner of the movies. I've exclusively given it to Sony. So then we have to get the content as well. I think additional some crores rupees we have given, and then we got that song tune, and then we have created this particular ad campaign. So we need to identify licensed stuff should be used while creating, generating, marketing content, and then probably you will be the owner of this particular content.
Okay, that is. Thank you. Thank you for such insights. Now, the other question is that, see, in this context, I mean, while it is also like in terms of reusing of the content, right? Where there is, I mean, like we marketers, we typically use Gen AI platforms to repurpose content and build something fast, specifically in the startup environment. That is that. But on the other hand, we ourselves are creating some original content. Like for example, now this is a form of our original content that we're doing. right? There are other forms of original content that are there, in terms of video or text that I would have created, right? Earlier, I mean, there was, in terms of protection, there were possibilities like, where you were able to do DMCA protection for your, content, website content or copies or everything, right? But in this scenario where, tweaking of content is so easily possible and reproduction is so easily possible by changing a few parameters, how do you think marketers can safeguard their content in that scenario? What is it that we can? Because see, with trademarks and a lot of things, those things, it's quite possible. Like, because there is a mechanism, there's a body where if you have trademark or you patented things, content is not something which is patented or trademark. It's very easy to duplicate or repurpose it on the basis of some this thing. So how do we take care of that? Because I see that's going to be the biggest challenge for marketers going forward.
Without doubt, Rohan, that's a very, very big question, and I'm thankful that we have brought that question. So I'll go it from the other angle because I want to make this thing interesting to the marketers, because practical marketing insights and strategies are relevant, and then we'll come on the legal part. So I believe that you can have all these visual and textual signatures in your branding, right? Where you incorporate signatures or tells, right? Could be a specific font, could be a taglines, could be design elements. When you're creating something, you should also be like little bit confident that it's your work. You have created it. It's not like that you have got it from somewhere and then you have copied it, because see, you are having pressure to deliver, and then you go on internet and you figure it out something. I'll tell you a very interesting story of Accenture as well. Just let me just finish on that part. So that is important. Together with, you need to identify what are the knockoffs or unauthorized remixes. So as a marketer, you need to understand that part, that what you are creating, it's original, right? Secondly, there are content recognition tools. So what you create, people identify this is original or this is not original, right? And there are also something known as remixing of the content. So when you are having a selective licensing, wherein I've told earlier that you hire an agency who do everything for you, then you will be out of the ambit because you put everything in the contract. But if you identify these things as a marketing strategy, then it will be easier for you to come over that threshold of creativity, and that will be considered as your work, right? With that, you need to incorporate couple of legal strategies when you are doing remixing and repurposing, which are one with respect to, as you have told, digital rights management, in terms of embedding metadatas or watermark your images or videos. That is very, very important, because when you are trying to enforce it, evidence has to be there in court of law, that how this particular thing is your work, right? I think non-fungible tokens are also of that category. So that has to be there. With that, registration of copyright, because as soon as you have it's a prima facie proof of evidence that this is your work, right? Your name will be there. I'm sure, if you're observing all the newspaper, they are just giving those copyright table, that okay, this particular work is owned by this particular publication house and all those stuff. So that registration is very important. With that, confidentiality clauses and non-disclosure agreement, wherein you identify while creating these remixing and repurposing the content, that this is your work, vis-a-vis legal strategies, vis-a-vis marketing way of doing things. Because then you are confident on both the sides, because sometimes you also have been called to court for as a evidence purpose, as an expert testimony, who have created the content. So then you need to, if you are go lock stock barrel and try to protect, prevent, secure your IP. So I was just telling a story of this Accenture. So I'm sure it's a brand Accenture only. So they have created one company and they have created a logo which is having, you understand that those chemical bonds are there, and you create one structure, right? So This structure was like this, and they have created some other structure in a different dimension. This company was registered 10 years back with that same trademark, and Accenture got it registered at I think 2023 24, and they said that we are Accenture, nobody can stop us, and we are the owner of the mark. And this matter went to Delhi High Court. In Delhi High Court, they realized that their marketing team, one of the guy, just got it from the internet, this particular logo, and just changed the configuration of the logo. Because if you see it from a different angle, you can easily make out that it's same logo which has been created. So they've been gone. So that's why I'm saying that when you're talking about marketing team, they should know. And when generative AI is there in place, they should know that where are their boundaries. They should be knowing even the terms and conditions of the chatbot they are using, because the major question in this particular litigation, OpenAI versus ANI, is like opt out mechanism, wherein you opt out stating that when you are using this particular portal, you will not be using something which is there on this particular websites or this particular system and all. So you need to be aware that what you are using, and through that what you are creating, and that has to be registered so that you can protect it. Otherwise it will be a, because all these legal journeys are little tiring. You need to explain a lot, you need to prove a lot, everything has to be there in the form of evidence, you need to go to court. But ultimately you need to bear the fruit of your earnings. So I think that if we are having a proper charter in mind of telling these marketing people how to move forward, then it will be great.
Okay, interesting. So now that's purely from a legal framework, right? I mean, the legal framework point of view. Now, with Gen AI, there is also the ethical compulsion. Like, there is uh, like legal kind of. I always felt there's an emotional and rational side to everything, right?
Yeah.
So legal framework becomes your very very rational side of it. Ethical to a certain extent is your emotional side of things, right? When it comes to AI powered marketing tools that we are using, they're becoming more sophisticated. Uh, I mean, there's a lot of push around personalization. A lot of improvements being made in terms of looking at personalization, more campaigns that could be around people's personality, their view, likes, and all of it, right? So, while using these tools, what are the considerations that us as marketers need to take into account, where the ethical component of it, and especially where ethical meets the legal part of it, right? I think so. Of recently, there have been a lot of controversies where people have said something, as and it's backfired massively, right? And there have been legal ramifications also of that, right? I mean, it's gone into the, I'm pretty sure you're aware of it. There are a lot of things, something that is happening off recently. I mean, it's not from the marketing point of view, but somewhere the communication is a very important component of marketing, the speech part of it, right? And it kind of intersects over there. So just throw some light on that aspect of it. That how can we as marketers walk that path and ensure, with this adoption of AI, we are on the right side of ethics as well as law.
Yeah. So see, what I believe, ethical considerations are couple of ethical considerations, because bias and fair representation has to be controlled and operated from the human point of view only, because AI do what humans tell them to do, right? And there is a algorithm behind it which works. So training your robots, all those things talks about biases, and disclaimers have to be put on certain places. Consent in terms of privacy and data security has to be there in place. And accidental plagiarism, like you have crowdsourced something, some images from open internet, and then you are not able to figure out something new because it has actually got the generated the images from the public domain images only. So that accidental plagiarism is always there, which being created by a generative AI. And unless and until you do a proper proofread. So there is a very interesting case law happened in US, and this particular lawyer has been, I think, has been reprimanded, not barred. So he put a brief in court of law stating that okay, this is the situation. There are certain cases cited in the brief. Everything is done through generative AI, and all those cases were fictional. There's no cases like those which he has mentioned in the brief. So he has to proofread it. He has to do quality check when he has created that particular brief. He got the brief, he put it in the court, judge gave the judgment. And then when it went to appeal, the other party identified where are these judgments so that they need to counter or rebut. Those cases were not there at all. So this is the ethical consideration wherein you need to be aware that whatever you have created has to be proofread, right? Unless and until your robot is giving you 100% results, right? So it happens in the marketing domain as well, right? If you're not aware about how the background of your generative AI robot is working, then it will be problem for you, right? So what I heard and understood that you can give all the tones to the robot, and then it will create a new lyrics for you, new this musical notations for you. So a lot of things can be possible, but then you need to see that how this can be done in an ethical manner, right? So what I realize when we intersect this particular AI consideration, ethical consideration with legal part, then couple of more things come into picture, which is known as consumer protection. So in consumer protection, we must talk about misleading claims. So I remember both in Samsung and in Flipkart, Walmart. So whenever my product team comes to me for the listing, and they say something on the listing, which they say as a claim that this is that. So I remember a very interesting incident wherein they came with a cloth paper towel. What is paper towel? Towel is cloth towel, right? So so this paper towel is having a more life because it is made with this material, and then it is also, it's a paper only, but it is having a more life. Like you can wipe or you can mop it in a more you know important, not more important, but I should say that it is having a life expectancy more. So then I asked them, give me the claim report. Have you done any kind of lab testing which shows that this particular material is having more durability? So those misleading claims should not be there while putting your marketing things, because I'm sure you understand search engine optimization, and when all you put are simple words like I want to buy a coffee mug, it will goes to the say Amazon only every time, because Amazon is having the unique description of a mug itself. Right? So those misleading claims should not be there, because now we have a CCPA, Central Consumer Protection Authority. Why I'm telling this, because there's a mass litigation concept in US. This has
Okay.
been incorporated in India by the Consumer Protection Act Amendment 2019.
Okay.
So like if you have done a misleading ad campaign and say 1,000 people got affected. I'm not talking about affected, but I'm talking about that 1,000 people have initiated a claim against you. So in that scenario, you need to take care of the uh, inquiry being done by the CCPA, and then the claims will be of that proportion itself.
Hmm.
So in that scenario, we
Right.
need to identify that consumer laws, and then of course ASCII,
Hmm.
Advertising Standard Council of India, they have a proper influencer guidelines. How you need to do these influence promotions, campaigns. You need to tell very categorically what are the material connections, whether it's a paid campaign, unpaid campaign. All those things has to be So I was, reading this very, very important SP guideline, and I'd like to, talk about this particular line. So they are saying it is critical that consumers must be able to distinguish when something is being promoted with an intention to influence their opinion or behavior for an immediate or eventual commercial gain. So if you read, this is the preamble of these SP guidelines. So consumers should not be duped in any manner, because they don't know that when the ad came, they don't know when the advertisement is happening or the marketing is being going on. So it has to be very much clear that they have been asked, showing that particular campaigns with the intent that they need we that the campaigner is trying to get some commercial gain, because it is influencing his mindset, and then he'll go and buy that product. So that has to be very clear. Finally, intermediary guidelines, right? So all these e-commerce platforms are intermediaries. It has been told that they have a safe harbor provisions, and they are being safeguarded, that anything bad may they won't be responsible, because sometimes it's a between seller and customers, they don't know.
Right.
But with respect to finance, with
Mm.
respect to health,
Mm.
they have been considered that they have an additional obligation. So
Okay.
there is a
Mhm.
intermediary ethics guideline which came in
Right.
2021, which needs to be followed, because in finance there's a monetary loss, and you need to be registered with SEBI as a qualified, say finance wealth management, what do you say, supervisor, or who is giving guidance. In nutrition and health, again, you need to know that you cannot claim something misleading. You need to be a registered FSSAI person, so that whatever you are saying, whatever you are writing, those should not be claims which are against the principle of food laws, right? So I think those two three things are very, very important, stating that ethical considerations in AI marketing campaign needs to be taken.
Okay, sorry, I just got a bit disconnected in between. I had a small pause. All right, I think so. I have more questions for you, but unfortunately, we are running short of time. We are already, I guess, 36 minutes around
Okay.
that.
Okay.
I do have, I think so, from the number of people who've sent me the queries on the basis of that you're going to be on my show. I have some questions around influencer marketing also. But I think so, our conversation is not complete. I believe this will warrant another round of discussion for us. I'm definitely we'd love to have you again on our show and have another round of discussion with questions that are, I think so, a lot of questions are now around influencer marketing also, because a lot of influencers are using Gen AI for content generation. And, that is where you as a brand do not have a lot of control on. So I think so that would be an interesting discussion for next time around. But for viewers of our show, you can find Rahul's LinkedIn profile in our description section. So in case you have any questions for him, please feel free to reach out to him. He's a wonderfully helpful person. He has been, answering a lot of queries of people where he's part of our communities, where, people have posted questions to him, and he's taken a lot of time in responding to all of them at length. So please feel free to reach out to him. And Rahul, I can't thank you for your time today. This is a very interesting topic. I think so. A lot of us have been smitten by the AI bug. I mean, we tend to call it the shiny object syndrome. But this was a very important aspect of it, because we see the evolution with every trend that comes into adoption. There is an evolution in that in terms of compliance or legal, like in data also, as we see over a period of time, the years, like how GDPR to, I think so, DPDPA is coming in India. So we'll see some evolution here. But it was a good insight in terms of for us to be prepared as marketers. Thank you so much for sparing time today. It was wonderful to have you on our show. And for all our viewers, please subscribe to our channel. We'll have Rahul once again on another show, another day, another time, taking few more questions from us on Gen AI and the legal implications of it. Thank you, Rahul. Thank you for your time.
Thanks a lot, Rohan. Thanks, everybody. Bye bye.